It's no small matter to transport and set up giant cranes to do steel work. The court agreed that the contractor who didn't pay rent for those cranes had breached the contract. But if the contract had been completed, the subcontractor would have lost money, so there didn't seem to be any damages to award. The court in United States v. Algernon Blair found a way around this problem by using an equitable remedy with a funny Latin name. Algernon Blair, Incorporated, entered into a contract with the United States to construct a naval hospital in South Carolina. Blair subcontracted with Coastal Steel Erectors, Incorporated, to supply equipment and steel work. Coastal brought its own cranes to the job site and began performing work under the contract. Blair refused to pay Coastal for rental of Coastal's cranes, claiming that it wasn't obligated under the subcontract. Coastal had completed about 28% of the subcontract, but it stopped work and terminated its performance when Blair refused to pay rent. Coastal sued Blair to recover for the labor and equipment it had already furnished. The United States District Court for the District of South Carolina found that the subcontract required Blair to pay rent for Coastal's crane, and that Blair's refusal was a material breach that justified Coastal's terminating performance. In determining damages, though, the court held that any amount that Coastal would have been due had to be reduced by any losses it would have incurred completing the contract. The amount due to Coastal was about $37,000, but if Coastal had completed the contract, it would have lost more than $37,000. Accordingly, the court denied Coastal any recovery. Coastal appealed to the United States Court of Appeals for the Fourth Circuit.